I'm looking for yeah, that's the whole thing. The restaurants. Yeah. She don't want to be on film. Just had the regular it's kind of a bit big. Well, I got to have it developed with the story. Yeah. She's 7 years old. The ship, the film grain, like this is Robert. They want to pull up leaders and challenge my manager.
All rise. Department 25 now in session. The Honorable Kathleen Delaney presiding.
Thank you, everybody. Please have a seat. All right. Going to call State of Nevada versus Ammar Harris. First on the calendar. Mr. Harrison from the Holden area. Go ahead and state appearances of counsel, please, while Mr. Harris is joining us.
David Stanton and Pam Weckerly on behalf of the state.
Thank you.
Good morning, Honor. Tom Erickson and Robert Langford on behalf of Mr. Harris.
Thank you, and I will note that Mr. Harris has now joined us from the Holden area. This is the date and time set for the sentencing in this matter. This is based upon the jury verdicts in the 11 counts as charged, inclusive of the first 3 counts of first-degree murder, in which the jurors pronounced the sentence of death for Mr. Harris. I will hear from the state with regard to arguments as to the remaining counts in the sentencing. I'll then hear from the defense. Mr. Harris, my understanding is, although statements were provided from the family with regard to the pre-sentence investigation report, and of course the families testified at the time of the penalty phase, that there is no additional testimony from any of the family members today. Is that correct?
That's correct. We'd incorporate their comments in the penalty phase before the
And I do have, and I have reviewed those. Mr. Harris did not submit a statement that I am aware of to the pre-sentence investigation report writer. However, Mr. Harris, of course, is welcome to address the court this morning. But let me hear from the state, and then we'll turn it over to the defense.
Your Honor, the state would ask that the counts 1 through 4 be consecutive to one another. They certainly have extreme relevance in PCR proceedings, and it obviously, factually and logically addresses a separate and distinct victim. The state would have no objection and believe it's appropriate that 5 and 6 be run concurrent. And the state believes that 7 through 11, one or more than one, should be run consecutive, as this court heard in detail the facts and evidence in this case, the danger to other members of this community based upon the defendant's actions, both with a firearm and his vehicle, were significant, pronounced, and they should be addressed by this court in a consecutive nature. Other than that, Your Honor, we would submit the matter to the court.
All right, thank you, Mr. Anderson or Mr. Langford?
Your Honor, there's not a lot that we're going to say at this point other than it's our position that given the 3 death sentences, that concurrent treatment of the other counts is completely appropriate under these circumstances. The other issue that we have is with the credit for time served calculation. We would be requesting the full amount of time since his arrest on April 15th, 2013, which would be 995 days credit for time served.
The pre-sentence investigation report reflects the 317 days. There have obviously been other matters that Mr. Harris has had before this court that would have been running at the same time. But what is the state's position with regard to the credit for time served?
Well, I believe based upon this court's prior sentencing, I reviewed the transcript. He received credit in the other cases, so by operation of law, those would not be, he would not be entitled to hear to those days that were credited in his other felony convictions before this court.
Mr. Erickson, anything further on that point?
No, Your Honor.
Thank you. Anything further with regard to the sentencing?
No, Your Honor.
Mr. Harris, do you wish to address the court?
No, ma'am.
The court has not prepared any specific remarks this morning. I don't know, the only thing that came to mind in preparation for proceeding today was, I don't know, Mr. Harris, why the random selection of your case assignments brought you to this department for each of your cases, but it did so. And the only thing that the court has endeavored to do throughout the course of these proceedings of your involvement with the state of Nevada is to be fair and impartial in those cases and those trials, and to do equal justice between yourself and the state of Nevada. The other cases have already been determined and resolved, and this is the remaining case in this particular circumstance. The jury spoke and determined that you should be sentenced to death for the first-degree murders of Mr. Bolden, Ms. Wasmund, and Mr. Cherry. And at this time, the court will pronounce your sentence as to count 1, first-degree murder with use of a deadly weapon. Per the jury's decision, you will receive death as prescribed by law in the state of Nevada, and that sentence is to run consecutive to cases C-289-275 and C-300-665. As to count 2, first-degree murder with use of a deadly weapon, per the jury's decision, you will receive death pursuant to law in the state of Nevada, and that count 2 will run consecutive to count 1. As to count 3, first-degree murder with use of a deadly weapon, you will receive death pursuant to the jury decision and pursuant to Nevada law, and that count 3 will be consecutive to count 2. Count 4, attempt murder with use of a deadly weapon, as regards the passenger with Mr. Cherry, he will receive a sentence of a minimum of 96, maximum of 240 months. That sentence to run consecutive to count 3, as well as the deadly weapon enhancement for count 4, which is an additional 96 to 240 months to run consecutive with count 3, and to count 4 as the deadly weapon enhancement. The remaining counts, it is the court's intent to run those concurrent. Count 5, discharge a firearm to a vehicle, will sentence you to a minimum of 28, maximum of 72 months, and then Department of Corrections concurrent to count 4. As to count 6, discharging a firearm into a vehicle, will sentence you to 28, minimum of 28, maximum of 72 months, and then Department of Corrections concurrent to count 5. As to count 7, I will sentence you discharging a firearm out of a motor vehicle, minimum of 72, maximum of 180 months, concurrent to count 6. As to count 8, discharging a firearm out of a motor vehicle, I will sentence you to a minimum of 72, maximum of 280 months, Nevada Department of Corrections, concurrent with count 7. As to count 9, discharging a firearm out of a motor vehicle, sentence you to a minimum of 72, maximum of 180 months, concurrent with count 8. As to count 10, discharging a firearm out of a motor vehicle, will sentence you to a minimum of 72, maximum of 180 months in the Nevada Department of Corrections, concurrent with count 9. And finally, as to count 11, discharging a firearm out of a motor vehicle, I will sentence you to a minimum of 72, maximum 180 months in the Nevada Department of Corrections, concurrent to count 10. Those sentences to be carried out, I will ask the state in a moment if they have prepared the warrant of execution as well as the state of execution, if you're prepared to provide those to the court today. If not, I assume those will be submitted to the chambers.
They will be, Your Honor. I thought they had been delivered to your chambers prior to this morning, but I'll ensure today that it gets delivered to your chambers.
Well, the court will take its time to review those documents to ensure that they are complete and appropriate in the circumstances. There are the other components of a sentencing, the $25 administrative assessment fee to the court. The DNA has already been ordered in the previous case, so that will not be imposed. There is restitution being requested regarding funeral expenses. I believe this is for Mr. Bolden's family. The victim number is VC223-1382 in the amount of $4,625.55. Other victims in the case have not made requests for restitution, so none will be ordered in their circumstances. And I will, based on what I believe is the correct operation of law in terms of the credit for time served and the credit being applied in other cases, I will give in this particular case, as the PSI notes, 317 days credit for time served. Of course, if there is some indication of why that should be otherwise, the court will hear any subsequent motion in that regard. Obviously, there will be any number of matters that the Supreme Court will now hear with regard to this case. I will turn this matter over to their consideration. I'm sorry? We will have to also prepare, and we will include, and my court just reminded me, an aggregate total for the sentencing. The court does not have that calculation this morning, but we will complete that calculation for the judgment of conviction. But again, as we noted, with regard to all of the charges other than count 4, with a term of sentencing, they are to run concurrent. So we ultimately have the 96 to 240, minimum 96, maximum 240 months of the Department of Corrections running consecutive with the death sentences, the other matters running concurrent to them. So that would essentially be the aggregate to the death sentence. But we will ensure that we have that properly set forth in the JOC. Thank you all for your time this morning. We are concluded.
Thank you.
Yes, thank you. Other questions, please? I do have State of Nevada versus Anthony Mayo. Yeah, Mr. Sosin, there it is.
Bob Stevens for the state, Your Honor. Thanks for calling this after trial attendant.
Good morning, Mr. Stevens.
Good morning, Your Honor. Dan Silverstein and Arlene Heshmani on behalf of Mr. Mayo, who's present in custody.
Good morning. Thank you for allowing us to call the other